Hey again, everyone. It's Rob Ryder, and it's Tuesday, November 2nd, 2021. Today I'm going to do a video on judicial notice and depositions or evidence because I have a few people that I'm trying to help file some evidence, right, under judicial notice or as a deposition, because both of those forms of evidence are covered under the rules of evidence of your state or the federal government. And under judicial notice, you can file judicial notice of adjudicated facts, or you can file judicial notice of the law. Or in the federal rules, it says judicial notice of legislative facts, which, sounds to me like, well, that would be an act of Congress, and, well, that's the law. So let's take a look at this, right? Let me finish up my opening statement here. So I'm Staff Sergeant Robert Allen Rutluski, U.S. Army veteran. Call me Rob Ryder. And my email address is courtofrecord@aol.com. courtofrecort@aol.com. And sorry I can't answer anybody's statements on the video, because when I do, they both disappear, the statement and my answer. So I'm not wasting my time anymore. But if you want to get a hold of me, well, there you go. There's my email address. So I need to start with something here that I got to make sure I still have opened up. Hang on just a second. Yeah, I wanted to talk about affidavit, right? This is out of the Bouvier's Law Manual, where it says an affidavit is an oath or affirmation reduced to writing, sworn or affirmed to before some officer who has the authority to administer it. It differs from a deposition in this, that in the later, the opposite party has had an opportunity to cross-examine the witness, whereas an affidavit is always taken ex parte. Right? So an affidavit is not evidence. An affidavit is an oath. Right? So back when, after the fiasco with the election, they had all of these attorneys running around getting affidavits from people and file them into court cases. Well, an affidavit isn't evidence. So while they may have filed an affidavit, they didn't file any evidence. And that's all you ever heard on TV is there is no evidence of election fraud. It's because nobody filed a deposition. They filed a fucking affidavit. And, it was done by Esquires. It's just part of how they do things. Esquires are making so much money right now with all this shit going on, everybody suing each other. It's what they want. They want the confrontation and the confusion. Right? So they had everybody file affidavits. What they should have filed is a deposition that has an affidavit in it saying that you're swearing to the statements that you made. And we'll have more on that in just a second. I'm just saying, that's why the thing that you need to file is, would be evidence. Because if you listen to what is being said on TV, on the internet, right, in all these cases, there's never any evidence. Well, then give them some. All right, hang on a second. I'll talk more about depositions in a minute, but I just wanted to show that this is out of the Florida Notary Handbook, and it's under the heading affidavit. And you look at it, and it's got, the jurisdictions up here. And then before me this day personally appeared, the name of the defendant who, being duly sworn, deposes and says. Okay, well, what does depose mean? In ancient usage, to testify as a witness, to give evidence under oath. Give evidence under oath. In modern usage, to make a deposition. To give evidence in the shape of a deposition. To make statements which are written down and sworn to. Well, it'd be like a sworn statement. To give testimony, which is reduced to writing by a duly qualified officer and sworn to by the deponent. So, what's a deposition then? A testimony of a witness taken upon interrogatories not in open court, but in pursuance to a commission to take testimony issued by a court under the general law on the subject. Well, apparently that's what a notary can do, because that's what the book said, that they're, this is out of the book. sworn and deposes and says. So this is somebody's deposition. So you can imagine right in here where it says insert fact, there'd be a bunch of writing, and then you have the signature in this at the end, right? This part down here, this is the affidavit certificate done by the notary, but this is your statement up here that you're going to swear to. And so this is really no different than this sworn statement form from the military, right? Where you're going to make a statement. You got a location. Well, that's the same as this, state of Florida, county of. Well, that's the location, right? Same idea. You got your statement, and you go to the end, and you have the affidavit, which is, done before. This would be a military officer, right? Well, we're not going to that jurisdiction. We're going to this jurisdiction. So, anyways, that's what would make it a deposition. They call it an affidavit, but it's actually a deposition. And if you file it as a deposition, well, then it's filed as evidence. But if you file it as an affidavit, well, then it's filed as a frickin' oath. And oaths can't be challenged. And what you want to do is put in evidence. So if the evidence isn't rebutted, well, then it stands as truth. The things that people call their affidavit of truth. You just got to get rid of the word affidavit. It's not a fucking affidavit. It's got an affidavit in it, but it's a deposition, sworn statement, testimony, evidence, but it's not an oath. It has an oath in it, and the oath is the affidavit part. Okay, enough harping on that. So hang on a second. See, because in the Federal Rules of Evidence, right, Article 10, the contents of writings, recordings, and photographs, right, this is, what makes evidence out of these things. Testimony or statement of a party to prove content. The proponent may prove the content of a writing, recording, or photograph by the testimony, deposition, or written statement of a party against whom the evidence is offered. The proponent need not account for the original. So you can put a deposition in and have it seen as evidence. Okay, well then, there's another form of evidence, though, that is under the 200, which is called judicial notice. Where are you? Sure got a lot of front-end stuff, right? Judicial notice of adjudicated facts. Now, this is all it has in the federal, right? These, the rule governs judicial notice of adjudicated facts only, not legislative facts. Okay, and it goes on to say what you can do to have things judicially noticed. But there's also, like in the state, where it has judicial notice of adjudicated facts, right? This is the Michigan Rules of Evidence, Rule 201, 202. They're all in the 200 section, wherever you are, right? These are the ones we're talking about, of your state's Rules of Evidence. Rule 202, judicial notice of the law. Court may take judicial notice without request by a party of the common law, constitutions, public statutes in force of every state, yada, 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 private acts, legislation. All right, so the law, basically. They may take judicial notice. Well, when is it conditionally mandatory? A court shall take judicial notice of each matter specified in paragraph A of this rule if the party requests it. Oh, so you got to ask them to. Motion to take judicial notice. Furnishes the court sufficient information to enable it to properly comply with the request and has given each adverse party such notice as the court may require to enable the adverse party to prepare and meet the request. Well, in most cases, the adverse party is an attorney who's doing everything by electronically filing. So that, as soon as you file it, he gets a copy. He's been noticed. Now, but you could go ahead and, do a proper service through the court and send them a copy. But I think they're noticed because they get electronic filing. Right? Furnishes the court sufficient information to enable it to properly comply with the request. Well, okay, so I want to judicially notice a law. I'm going to give them a copy of the law to say, here's the law that I want you to judicially notice. So they don't have to guess at it. What did it say in New York? See, it says a little different, right? When judicial notice shall be taken without request. Every court shall take judicial notice without request of the common law, constitutions, public laws, or public statutes of the United States in every state. Well, here they say you don't have to have requests. Michigan said you had to have requests if the party requested. Right here it says you don't have to request it. Well, to me, a request would be doing it by motion, right? Instead of just going to the court with a document that says judicial notice, here, I want to file this evidence. This judicial notice is evidence, right? Then I'm not requesting the court to allow me to. I'm just taking it to them and say, file this as evidence as a judicial notice, right? So if you're doing these things, pay attention, right? This is what I'm asking you to do, right? You're going to go there and tell them the document that I've written for you that you want them to file as judicial notice. And see what they do. If they say, no, they can't, they have them home, well, just leave it and say, no, you've been served, take it to the judge, get his decision. I'm not taking your decision. You're just a freaking counter troll, right? The court's been served. Go take it to the court. Let them decide. And leave it and walk out, right? Call me and tell me what happened. We'll, go to plan B, whatever that turns out to be at the time. Right? But I want them to take judicial notice of certain facts and laws, right? And then write a deposition explaining how those facts and laws affect you in your case and why you should be given relief. And if none of that shit's disputed, well, then it stands as truth. So let's look at a marked up judicial notice I did for somebody. All right? So here's just to give you an idea. So this guy's in a foreclosure. Right, so but this really doesn't matter what the case is. It may change some of the adjudicated facts or the laws are going to be pointed out. But by and large, this would be for anybody, right? Any kind of court case. So just look at what I'm doing, right? And imagine what it is I'm doing. And you could do it yourself. So, let's just look at a document that he got. Right, this was the affidavit as to non-military status. Right, and it says at the top, in the circuit court for the 9th Judicial Circuit in and for Orange County, Florida, General Jurisdiction Division with a case number. Well, there is no court named in the anywhere. It could be the circuit court of the 9th Judicial Circuit in and for Orange County, Florida, but it's not in the. Right, and this is what they do. It's like them not using your proper name. They're not using the proper name of the court. Right, so what's the proper court for Orange County where this is, right? Well, go look at the website. Right, proudly serving Orange and Osceola counties, right? It's the 9th Judicial Circuit Court of Florida. That's the proper name. So right off the bat, the paperwork that the plaintiff is putting in is a simulated legal process under color of law because it's going to a court that doesn't exist. Okay, so, well, I think I'd like to complain about that. Anyway, so this is judicial notice of facts and law. So I, state your name, a citizen of the United States. Yes, you are under the Constitution. It says citizen of the United States, just like it's written there. Citizen of the United States is in the Constitution. Protected by and a defender of the Constitution of the United States and the paramount interest holder in all property contested under this case number. Now, people will tell you there's 3 different constitutions at least, right? But I'm not talking about the fucking Bill of Rights. I'm talking about the Constitution, the 6th article. It never changes. No one's ever shown me a Constitution where the 6th article says anything other than what it says. That's what I'm talking about. And as far as the Constitution of the United States, that's what the pocket Constitution is they hand to military people. It says it's the Constitution of the United States. That's what I'm talking about. If you don't know what that is, then I can't help you, right? But if we can all agree, well, that's what I'm talking about, well, that's what I'm using as my evidence for the things I say. Right? Constitution of the United States. And the paramount interest holder in all property contested under this case in this bogus named court inform that tribunal and the 9th Judicial Circuit Court, which is the proper name of the court, of their duty to take judicial notice of the following facts and laws as required by the Florida's rules of evidence. Take judicial notice. The 6th article of the Constitution of the United States, the supreme law of the land, decrees the senators, representatives before mentioned, the members of the several state legislatures, and all executive judicial officers, both the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. If you can find me a copy of a Constitution where it doesn't say that in the 6th article, send it to me. Otherwise, we have to agree that's what the 6th article of the Constitution says of any version. In the 3rd section, right? Take judicial notice. It is a fact that Black's Law Dictionary, 2nd edition, defines a judicial officer, which is mentioned up here. So, well, what the hell is a judicial officer? Well, hey, Black's Law says it's a justice of the peace, a magistrate or judge, or any other officer of the court. Oh, well, who are the officers of the court? Well, take judicial notice. It's a fact that NOLO's plain English Law Dictionary defines officer of the court as any person who has an obligation to promote justice and uphold the law, including judges, clerks, court personnel, police officers, and attorneys, who must be truthful in court and obey the court rules. Well, just in those first 3 statements that they file this, right, you've already identified that attorneys need to take an oath to satisfy the Constitution. So where is it at? Take judicial notice. An act to regulate time and manner of administering certain oaths, that'd be that Exhibit 1, is the first act of Congress signed into law after the ratification of the Constitution of the United States, 1 Stat 23, and legislates that the oath or affirmation required by the 6th article of the Constitution of the United States shall be administered in the form following, to wit, I state your name, do solemnly swear or affirm that I will support the Constitution of the United States, period. And such officers shall incur the same penalties in case of failure as shall be imposed by law in case of failure of taking their respective oath of office. Well, in King Henry VIII's time, if you didn't take your oath of office, it was treason. It's a loyalty oath. And, you need to take these oaths before you start exercising the powers of the office. So take judicial notice for U.S.C. 101, oath by members of the legislature and officers derived from 61 Stat 643, legislates that every member of the state legislature and every executive officer and judicial officer state shall, before he proceeds to execute duties of office, take an oath in the following form, to wit. Hey, that's that same oath again. And then for U.S.C. 102, same, by whom administered, derived from 61 Stat 644, next page is 61 Stat, requires record or certificate, therefore, to be made. That'd be our second exhibit. Right, these are the things to give to the court so they know what you're talking about. Give them an exhibit. Describe what it is here. Give them the exhibit so they can read the whole thing for themselves. Take judicial notice, Exhibit 3, 50 U.S.C. 4012. Now, this will apply to anybody in a civil case, right? This is the thing to do with the Service Member Civil Relief Act and the non-military affidavit and so forth, right? Well, there's a law. It's 50 U.S.C. 4012. Certificate of service, persons reported missing, derived from 117 Stat 2859, legislates that in any proceeding under this chapter, right? If you go read the chapter, it'd be like a foreclosure, tax issue, any kind of issue, right? If you're in the military and you have any of these things, well, they they need to prove you're not in the military, you're not, and that you have to come answer this now because of you're not called away on duty. So to do that, though, in any proceeding under this chapter, a certificate signed by the Secretary concerned, that'd be the Secretary of the Army, Secretary of the Navy, Secretary of the Air Force, Secretary of Space Command, is prima facie evidence as to any of the following facts stated in the certificate. It is a law of the United States concerning the Service Members Civil Relief Act and requires that this law certificate be filed by the plaintiff to establish military status of the defendant. Well, that's not the form they filed. Long story short, they put in some other piece of BS paperwork that they call the affidavits as to non-military status. Filed by the attorney for the plaintiff, he actually filed 2, are not prima facie evidence of my military status, nor are they an affidavit as they were not sworn to before a proper officer. Now, that's just by looking at the documents and saying, well, what's an affidavit? What are they supposed to do? Right? Looking at what it says compared to what the law says and say, well, they didn't do what they're supposed to. I'm going to put it down. If it doesn't get rebutted, then I guess I'm right. Take judicial notice, 18 U.S.C. 371, conspiracy to commit an offense or to defraud the United States. Makes it a crime if two or more persons conspire either to commit any offense against the United States or to defraud the United States. Well, if we have people who didn't take their oath acting like they're judicial officers, and you got more than one, well, that's a conspiracy against the United States, because it's the United States that said you had to take the oath. Right? Ratluski didn't say it. The frickin' Constitution did. I'm just trying to defend the Constitution. Take judicial notice, 1 U.S.C. 112, statutes at large, contents, admissibility, and evidence not acknowledges United States statutes at large shall be legal evidence of laws in all courts of the United States, the several states, and the territories of the United States. That'd be my 5th exhibit. Take judicial notice that Florida statute chapter 843 makes it unlawful to use badges, other indicia, or criminal actions under color of law through which or through use of simulated legal process, the crime of obstructing justice. So to find this chapter for your state, just simply put the name of your state and say impersonating an officer. Right? Michigan, impersonation of an officer. Ohio, impersonation of an officer. And, you'll find it. Google will take you to it. And you say, oh, this is the chapter. You might find the section, but then that section is in a chapter, and that chapter has all sorts of things in there that, are obstructing justice or some other kind of thing. And, well, I'm going to point it out, because take judicial notice. It is a fact that in the Circuit Court of the 9th Judicial Circuit, and in Fort Orange County, Florida, is not the Judicial Circuit Court of Florida. We already said that's the 9th Judicial Circuit Court of Florida. That's the only name that will do. Anything else is a simulation of a legal process. Put it down there, right? If they don't rebut it, then everybody agrees it's not a Judicial Circuit Court of Florida. Take judicial notice. It's a fact that the attorney for the plaintiff in this case filed with the Orange County Clerk a motion for an order from the Circuit Court, the 9th Judicial Circuit in Fort Orange County, Florida, on 9/1/2021, and also requested on the same filing a final judgment of foreclosure from a differently named tribunal. Right? So this was a 2-part document, and for one part it used the first name, and the second part it used this other name, which is not the same, right? In the Florida Court of is not the same as in the Circuit Court of. We don't need to go any further. It's different. But you could, what I did is copy and put them both underneath each other and say, hey, these two don't match up. And that neither of these entities are Judicial Circuit Court of Florida. Let's just put it on paper. Say, hey, this is, it's a fact. Now, the judge can either agree with you or say he's not going to accept it. But if he agrees with you and puts it in, well, now it's evidence of the fact. Okay, so take judicial notice. It is a fact that the Florida fixed rate note signed by me in good faith on 5/3/18 was converted to a check with a blank pay to the order of line as evidenced by documents filed as attachment by the plaintiff on 3/13/2020 with the Orange County Clerk. So this applies to anybody with a foreclosure, right? When they file your foreclosure, they put a complaint in, they put in a summons, and then they're going to put in a bunch of other paperwork. One of them will be the note, and the other one will be like the mortgage or whatever they're saying you owe money on. If you look at the note they filed, they've taken the last page, and they've added a blank endorsement. It says pay to the order of. It's got a blank line, and then it's got without recourse the name of a business or the bank or whatever. And, right? So what they did is they took your note and they securitized it, which means they converted it to a check. But because it's blank, they can keep it on deposit in their account as bank money, and they don't have to take it out of the till as legal tender. But it's supposed to be paid on demand, right? So if you had that check and you put your name on that line, you could take it to that bank and they have to pay it. They're not doing it. All right, so take judicial notice of the fact that I am the proper payee of the check referenced in point 12. Claim the check. take judicial notice of the fact that the case proceeding in the fictitious court obstructs justice. Just go ahead and call it a crime right off the bat if it doesn't get rebutted. Right? Or if the judge accepts all these points, right? Because he's going to be the trier of the fact or the trier of the law. Right now, it won't be the jury, it'll be the judge. He'll be the trier of these facts. If he agrees with them, well, then that's what happened. Okay, but let's put that in. Let's quickly look at the different exhibits that we're going in. Exhibit 1 is 1 Stat 23, which says that the oath of affirmation required by 6 of the Constitution of the United States shall be administered in 5 more. I think I put that in there, right? So it does say it. And it says down here in 4 that persons who shall be authorized by law to administer such oaths or such officers their respective oaths of office, and such officers shall incur same penalties in case of failure, and shall be imposed by law in case of failure of taking their respective oath of office. It's their fault that they don't do it. All right, and then this is for USC 101 and 102. All right. Every member of the state legislature and every executive and judicial officer of the state shall before he proceeds to execute the duties of his office, take an oath in the following form, to wit, I, A.B., do solemnly swear that I will support the Constitution of the state. Well, they haven't done it. If they haven't done it and they're pretending to be a court, well, now they're simulating a legal process under cover of law, and they're maliciously prosecuting you. And all these people have liability insurance, and malicious prosecution is covered by liability insurance. In fact, I got to go show you that law. Okay, so I didn't find this in Florida, but I found this in Michigan. I'm not saying it isn't in Florida. I guess I didn't look for it at the time, right? But under the Michigan, Judicature Act, which is an act of the legislature, right? So this is a law. Malicious prosecution or action. Every person who shall, for vexation or trouble, maliciously cause or procure any other to be arrested, attached, or any way proceed against by any process or civil or criminal action, or in any other manner prescribed by law, to answer to a suit or prosecution of any person without the consent of such person, or where there is no such person known, right? They never use your proper name, shall be liable to the person so arrested and attached or proceeded against in treble the amount of damages and expenses which by any verdict shall be found to have been sustained and incurred by him. So the court can issue a verdict to say you've been damaged this much, right? And you can have treble damages. And shall be liable to the person in whose name such arrest or proceeding has been had in the sum of $200 damages, and shall be deemed guilty of a misdemeanor, punishable on conviction by imprisonment in county jail for a term not exceeding 6 months. So I would really encourage anybody who might do this to go try to find in your state's laws a section to do with malicious prosecution, and make sure that you put it in your judicial notice. Right? I mean, that's if this works, right? But I'm just saying, you put that in there, and it doesn't get rebutted, well, then it stands as the truth. Where was I? So, almost done. Almost done. Okay. Exhibit 4, 18 U.S.C. 371, conspiracy to commit offense or defraud the United States. I'm saying that's what's happening. And any time that somebody doesn't take the oath of office they're supposed to. Exhibit 5, 112. Right, 1 U.S.C. 112. So all these you can get online. This is all stuff online. All you got to do is Google 1 U.S.C. 112. Look for the GPO website, Government Publishing Office website. You can ask for it as a PDF, and it comes out in this nice printed form, and right, and it says the Archives of the United States shall yada yada yada. The United States statutes at large shall be legal evidence of laws. Well, you get the idea, right? That's what we put in. Now, with it, we put in, or I want to try to put in a deposition. So the idea would be first to file this here, the judicial notice with the exhibits, all the way to the end of this file, right? And tell them you want a certified copy or file stamped copy or whatever the hell you want to call it. Right? And then take that and write on it Exhibit A and file it as the Exhibit A that goes with this deposition, right? Which is the deposition of whatever your name is, comma, victim. Same heading at the top, same, right? Now this is just taking this form here and expanding it to put in some stuff, right? Make room for some facts. So before me this day personally appeared, your name, who being duly sworn, deposes and says. Well, if I'm going to depose, I'm going to call it a deposition, because depositions are one of the forms of written document that can be filed as evidence into a court case, but an affidavit isn't. Okay, evidence of, let me see, I, a victim of a crime against the United States in Florida by public officer imposters impersonated as judicial officers who are maliciously prosecuting me before a tribunal not recognized by the laws of Florida using the simulated legal process in yada yada. So, basically that's what I said in the judicial notice. Now I'm just saying it in a paragraph. Evidence of judicial officer imposter crimes are the laws of the United States and Florida I incorporated into the judicial notice of facts and laws that these individuals are offending by their omission of executing the proper oath to satisfy the 6th Article of the Constitution of the United States. Exhibit A, which is, this judicial notice with all the exhibits that you just filed, right? And now you're going to put up here Exhibit A on your file stand copy and file it again as the exhibit for this. Right? That way this has the facts and laws you're talking about it as part of its exhibit. That's why I'm doing it, so they can't say the two aren't connected somehow. I had previously requested Exhibit A be filed as a judicial notice into the 9th Judicial Circuit Court of Florida as evidence. I demand the offenders be prosecuted for their crimes and that I be compensated for the damages to my life, liberty, property, rights, titles, and interest. As a defender of the Constitution of the United States, I inform any and all persons acting as a government executive or judicial officer in the United States and this state, including all lawyers, that they must execute the oath in 1 Stat 23 of the United States statutes at large, later codified in the United States Code as 4 U.S.C. 101, for state officers prior to executing his or her office. Failure to comply with this Constitution, with the Constitution of the United States, will result in your imprisonment. Sworn to affirm by me, this is you, personally known. No, I wouldn't have to do that. I'd produce some ID, right, and type the ID produced and what its number is. So if it's a driver's license or state ID, whatever it is, and put the number on it. If it's a military ID, well, say that it is and put the number on it. Right, and then give it to the notary so the notary can do her thing. One problem with this, though, I can see right now, dang it, I didn't leave the guy a line to sign it. So, there would be one more line here, which would say signature of affiant with a line for the signature. But he can just sign right here. He just can't do it before he's before the notary. You don't really need to have a line to sign on. It's the next thing to do, so just sign it right here when you're in front of the notary. Very good. All right, now I wanted to show the garbage they put in, because again, this applies to anybody. If you are going to be 50 U.S.C. 4012, the certificate I'm talking about, we really didn't look at that. Let's go take a look at it. I got a little carried away there. Here it is, Title 50. Right, 50 U.S.C. 4012, Certificates of Service, Persons Reported Missing. Prima facie evidence. In any proceeding under this chapter, a certificate signed by the Secretary concerned is prima facie evidence as to any of the following facts stated in the certificate. that a person named is not, has been, or has not been in the military service. I'll let you read this yourself, but we really would like to have a copy of the certificate, especially if you serve, because I say we're all still in the military. We've not been released. Right? So, like I did 8 years, I'm a veteran, but I'm still in the military. I'm just not serving on active duty. So I should have an ID card. I should be getting compensated for my time, yada, yada, yada. They could have released me, but they didn't, right? They had the choice under law to hold you until 6 months after the war ends. And there's always a war, so they don't have to ever let you go. And if they did let you go, then there has to be a discharge order releasing you from the custody and control of the military. Right? And I don't know any veteran I've ever talked to, and I've done a lot of videos and had a lot of veterans contact me. Nobody has such a freaking order. So we really want to have them get this certificate for us. Right? My point is, this isn't the certificate they're getting when they do this affidavit of non-military status. Right? Some attorney here is going to commit perjury. Right? This Esquire. Because this really isn't an affidavit. Right? He's not doing it as an affidavit. But he's going to file this piece of paper here, which is the document that you can go to a particular website. If you say, status report, Service Members Civil Relief Act, and YouTube, it'll take you to the site. And you put in a name, and it'll tell you if they have any status. But upon searching the data banks of the Department of Defense Manpower Data Center, based on information that you have provided, right? So right away, well, if they gave them the wrong information, of course they're not going to find anything. But the other thing is the Department of Defense Manpower Data Center isn't the official custodian of your documents. Right? The secretary of your unit or your services. And this is the Department of Defense Manpower Data Center. He's the guy that signed it, and it said it had to be signed by the secretary. Right? It's really, it's a good law. We'd really like to get them to have to use it. And we want to get this certificate. Right? Because this certificate is going to prove that we're still in, and that, if you've been carried as missing this whole time, then you've been being paid every month, just like you were on active duty. Been getting promoted, just like you're on active duty. Been getting retirement, just like you're on active duty. All of it's there. It's all in there. It just isn't going to you. It's going into some fund someplace, right, that they're living off the interest on. And what they want to do now is collapse the frickin' system and take the, and forget the interest. They want to go after the frickin' the principal. Like in the military retirement fund, there's over $1 trillion of paid retirement sitting there on deposit waiting for somebody to claim it. Well, that's, just one fund. If you go look at your comprehensive annual financial report for your county, you see they have hundreds of millions of dollars, maybe billions of dollars, right, that is stuffed in all these accounts. So why are they still collecting taxes? There's just money that's been stuffed in every frickin' hole they can, and now they want to claim all that frickin' principal and, shut down the economy. I say, oh, no, that's mine, brother. Hey, that's mine. I want the certificate to prove I'm in the military. So I can, go to the next step, which is try, and I talked about my last video, was try to find the employee of the Veterans Administration who has the delegated authority that's delegated by 38 CFR Section 2.3. Right, which allows this person to use the seal of the VA on their documents, and it's prima facie evidence any place you file that document. So, this is a big deal. The thing about the evidence is the big deal. Okay, hang on a second. Okay, so again, I'm doing this mainly because there are a few people that I'm asking to do this. I'm trying to make sure that everybody understands what it is I'm asking you to do. Right, that you're going to take your judicial notice of facts and laws, however I've written it at this time, right, with whatever exhibits I said, and take it down and get it filed. And tell them to file it as a judicial notice. It's evidence. Right? If they do that, well, then that's what I want it done. That'd be wonderful. Send me a copy, show me it got done. But understand that if that happens, right, and the judge doesn't rebut any of these issues, then he agrees with all these issues, right? He just tried the fact that he agreed with you. And the way this thing is written, it says that what's happening right now obstructs justice. We're saying that they've committed a crime. And if the judge agrees with you, well, it's a great day in America. And then beyond that, because this is really just a bunch of facts, right? Whatever you want to write as your, I just want to get right down and say, I've been harmed. I'm pointing out the crime. And what's supposed to happen, under, the common law of England, if you pointed out that the king's law had been violated and you'd been harmed, then the king had a duty to defend his law and get you your relief. Right? And that's all we're doing. We're pointing out, hey, I'm defending the Constitution, saying these people don't have an oath of office. So, Ninth Judicial Circuit Court of Florida, the de jure court of Florida, do something about it. Well, we'll see if they will. But you had filed the deposition after you had filed the judicial notice with the exhibits. Get a file stamp copy. Right? Then go and do this. You could actually have this done already. I'm just saying, get that file stamp copy. Then at the top, just write on it Exhibit A and hand them the deposition. Say you want to file a deposition with an exhibit. And the exhibit just happens to be the thing you filed just a few minutes ago. But, well, who the fuck cares, right? It's you. You can do whatever you want to do. Excuse my French, right? But this is a big deal. You want to get the thing in with the evidence so that everybody knows what it is you're talking about. And if it doesn't get rebutted, well, then your deposition of truth stands as fact. And what you did is you swore to your statement. So the affidavit's at the bottom. We're just basically doing what this form here says from the Army. Right? I'd love to do this form with the Army, but I can't find the proper officer to do this. But apparently, according to the notary handbook, the proper officer to do it, the way that I'm showing, is a notary. Right? Notary signature. This is the part I left out. Signature of affinity. Didn't leave a place to put that on there. But see, it's just a line with the signature on it. So draw a line, write your name on it. And stick that in right about here. It'll all be good. Well, very good. I'm going to cut it off here and post this thing. And you'll have a great day. See ya.